crack in the wall of 90 years. Imagine this. For nearly a century, there's been a wall built around your constitutional rights. That wall is called the National Firearms Act of 1934. It wasn't just a law, it was a strategy. Lawmakers knew they couldn't outright ban firearms like suppressors or short-barreled rifles, so they did the next best thing. They taxed them into near extinction. For 90 years, the $200 tax stamp acted as both gatekeeper and deterrent. In 1934, $200 was worth about $5,000 today. That meant only the wealthy or determined could afford to comply. For everyone else, it was essentially a ban, disguised as law. But here's the shocker. In 2025, Congress changed the rules. The $200 tax was reduced to zero, and with that, the entire legal foundation of the NFA cracked wide open. Because if the law's only justification was taxation, what happens when the tax disappears? This is no small policy tweak, it's a nationwide legal earthquake. It challenges whether the federal government has the constitutional authority to regulate suppressors and short-barreled rifles at all. Politicians are panicking, lawsuits are multiplying, and courts are being forced to revisit questions they've ducked for nearly 100 years. And here on Survival Firearms, we'll break down exactly what's happening, how Congress pulled the trigger on this collapse with H.R. 1, why some lawmakers are scrambling to reinstate or even increase the tax, the lawsuits aiming to dismantle the NFA piece by piece. The state-level fights are emerging as a second front, and what this all means for you, your rights, and the future of gun laws in America. So buckle up. This isn't just about suppressors and short barrels. It's about the future of the Second Amendment itself. Chapter 1. The cracks in a 90-year-old law. The NFA wasn't born out of calm debate. It came in the shadow of gangsters like John Dillinger and Al Capone, when shootouts filled headlines and politicians needed a quick fix. But they knew banning firearms outright wasn't constitutional. Instead, they relied on something less obvious: the power to tax. Why it worked? $200 in 1934 was an impossible sum for average Americans. It priced ordinary citizens out. The legal foundation. The Supreme Court upheld the NFA on one simple basis: Congress has the power to tax. That's it. The problem now, with H.R. 1 reducing the tax to zero, the entire justification for the law evaporates. If it's no longer a tax, what is it? This chapter of history matters because it explains why the NFA is vulnerable today. It wasn't written as a sweeping gun ban, it was written as a tax law, and without the tax, the government may no longer have authority to enforce it. Chapter 2. The Backlash and the $479 Proposal. The response to H.R. 1 was instant and loud. Supporters of the NFA saw the danger. Without the tax, lawsuits would come fast, and courts might finally tear down the whole structure. Enter Senator Chris Murphy, who proposed an amendment to raise the tax to $479. Why $479? It wasn't random. That figure mirrors the crushing weight of the original $200 in today's dollars. The motive? Not to raise revenue, but to restore the NFA's shaky legal ground. The playbook. It's the 1934 strategy recycled to price ordinary Americans out of exercising their rights. But here's what matters most. The very fact that lawmakers rush to reimpose a tax shows they know the NFA is fragile. If they believed the law stood strong without it, they wouldn't be scrambling this way. That panic is proof of weakness. Chapter 3. Lawsuits on the attack. When H.R. 1 passed, it lit a fire under gun rights groups. Organizations like Gun Owners of America, the Firearms Regulatory Accountability Coalition, FRAC, and the Second Amendment Foundation wasted no time filing suits. Their argument is devastatingly simple. The NFA was upheld as a tax. Congress reduced the tax to zero. Therefore, the NFA no longer has constitutional authority. What do these lawsuits want? A declaration that the NFA's registration and transfer requirements exceed Congress's powers. An injunction blocking ATF from enforcing those requirements on untaxed items. In plain language, they want the courts to admit the NFA is unconstitutional in its current form and stop enforcement. And because multiple lawsuits are being filed in different jurisdictions, pressure is building on courts nationwide to confront the issue head-on. Chapter 4. The State-Level Battles. While national organizations hammer the federal government, state-level groups are targeting local bans. States like California, New York, and Illinois still prohibit suppressors or short-barreled rifles outright. Advocacy groups argue if the federal government no longer justifies these restrictions as a tax, states have no business banning them either. modern public safety arguments don't pass the Bruin test, which requires a historical parallel from the 18th or 19th centuries. This two-pronged attack, federal lawsuits against the ATF and state lawsuits against local bans, is deliberate. By hitting both levels at once, advocates maximize their chances of a nationwide shift. And the timing matters. The more courts weigh in, the harder it becomes for others to avoid addressing the core question. Chapter 5. Why this fight matters. It might sound like this is just about saving $200, but in reality, this fight strikes at the heart of how government justifies restricting rights. For nearly a century, the NFA's defenders leaned on a single line. It's just a tax, and Congress can tax. That shielded a complex web of restrictions, delays, and registrations. But now, with the tax reduced to zero, that shield is gone. The ripple effects could be enormous. Suppressors, SBRS, SBSS, no longer subject to the NFA's registration or delays. Broader definitions. Challenges could expand to other NFA-linked items like pistol braces or forced reset triggers. Future bans. Even modern assault weapon laws may face new scrutiny if courts decide the NFA framework is unconstitutional. This isn't about paperwork. It's about whether the government can hold your rights hostage behind red tape. If the courts strike the NFA down, it won't just be a win. It'll be one of the most significant rollbacks of federal gun control in American history. Chapter 6. The Courtroom Battlefield. The lawsuits filed by Gun Owners of America, FRAC, Palmetto State Armory, and Silencer Co. aren't just paperwork. They were strategically filed in the Northern District of Texas, a federal court that's become a flashpoint for Second Amendment rulings. This is the court that issued landmark opinions on 80% receivers, pistol braces, and forced reset triggers. Each time, the rulings rattled the ATF and forced appeals courts, and sometimes the Supreme Court to weigh in. Filing here was no accident. Advocates know this court has already shown a willingness to enforce Bruin's text, history, and tradition test, even when it means striking down long-standing federal rules. But there's an element of risk. The assigned judge, Judge Hendricks, doesn't have a deep track record on gun rights. That makes the outcome at the district level unpredictable. Still, gun rights lawyers have a plan. Step 1. Argue the case aggressively at the district court. Step 2. If they lose, fast-track the appeal to the Fifth Circuit, which has a stronger record of protecting constitutional rights. Step 3. Force the issue to the Supreme Court, which now has a conservative majority that has already shown in Bruin and Heller that it takes the Second Amendment seriously. This isn't about one win or loss. It's about building a ladder of appeals until the highest court in the nation answers the unavoidable question: can a law that rests entirely on taxation survive when the tax itself is gone? Chapter 7. The Gun Owner's Reality Check. Suppressors and short-barreled rifles may sound niche. Some gun owners think, that's not my fight, but the reality is far broader. The NFA created the model for modern gun restrictions: paperwork, registries, waiting periods, and background checks. If the NFA collapses, here's what changes. Template destroyed. The legal logic behind dozens of other restrictions evaporates. Broader protections. Courts may have to reevaluate how they treat everyday gun owners during encounters with law enforcement. Context matters. No longer can a court simply ask if an officer felt threatened in the last second. Judges must look at the entire sequence of events, from the stop to the interaction to the officer's decision-making. This shift restores balance. For decades, responsible carriers were one misunderstanding away from being treated as criminals. With the courts now focusing on context, not split seconds, lawful actions, like informing an officer you're carrying, can no longer be twisted into justification for force. For every gun owner, even those who never plan to own a suppressor, this battle matters. Because if the NFA framework falls, the government loses its favorite playbook for controlling your rights. Chapter 8. The Second and Fourth Amendments converge. The brilliance of this moment is that it's not just about the Second Amendment. It's about the Second and Fourth Amendments working together. Traditionally, the Second Amendment was about your right to own and carry. The Fourth Amendment was about your right to be secure from unreasonable searches and seizures. But under the NFA, the two often clashed. Owning certain firearms made you subject to surveillance, registries, and delays. In practice, exercising one right weakened the other. Now, lawsuits are arguing something revolutionary. If lawful ownership is protected by the Second Amendment, then being harassed, seized, or punished for exercising it violates the Fourth Amendment. This convergence creates a powerful shield. The government can no longer treat possession itself as inherently suspicious. They must prove actual contextual danger. For the first time, courts are being pushed to recognize what the founders always intended, that your right to bear arms is inseparable from your right to live free of arbitrary government intrusion. Chapter 9. The Road Ahead. If the NFA falls. So what happens if the courts strike the NFA down? The changes would be nothing short of seismic. Registry collapse. The federal database for suppressors and SBRS could vanish. No tax means no registry. Ripple effect. Other NFA-based rules would be at risk, including pistol brace restrictions, forced reset trigger bans, future assault weapon definitions, legal dominoes. Once one piece falls, it creates a precedent that makes it harder to defend the rest. On the other side, if the plaintiffs lose, it doesn't end the fight. Appeals are guaranteed. Lawsuits in other states will continue. And eventually, this issue will land before the Supreme Court, where the majority has already signaled its willingness to enforce historical tests strictly. Both sides know this is history in motion. That's why the stakes, and the intensity, are higher than they've been in decades. Chapter 10. Why this moment matters for every citizen. At its core, this isn't just about firearms. It's about whether laws can outlive their own foundations. If the NFA survives without its tax, Congress would gain a dangerous precedent. They could justify any law retroactively, even if its original legal anchor disappears. If the NFA falls, it forces accountability. Laws must stand or fall based on the authority under which they were passed. No more moving goalposts. That principle matters for every American, because if the government can keep propping up outdated laws with shifting justifications, then no constitutional right is safe. But if the courts draw a hard line, then freedom, not bureaucracy, sets the limits of government power. This is why the current battle isn't just a gun issue. It's a constitutional issue, and its outcome will echo across every debate about liberty, rights, and government overreach for generations to come. The fight of our generation. So here's where we are. The $200 tax stamp that propped up the NFA for nearly a century is gone. Lawsuits are in motion from every direction, and judges are being forced to confront a question that could redefine the Second Amendment for the next 100 years. If the lawsuits succeed, the registry collapses, and the government loses one of its biggest tools of control. If they fail, the appeals will climb, and the fight will continue until the Supreme Court weighs in. Either way, this is the turning point. Now, I want to hear from you. Do you think the courts will finally strike down the NFA's restrictions? Or will Congress find new ways to keep the system alive? Drop your thoughts below it, because this debate isn't just happening in Washington. It's happening here, in our community. If you found this breakdown valuable, share it with your friends and fellow gun owners. They need to understand what's at stake. And don't forget to subscribe to Survival Firearms, where we cut through the noise and bring you the truth about every battle that shapes your rights. Stay informed, stay prepared, and above all, stay free.